accepted. With all due deference to the legislature, I mean, they pass statutes. Some of the statutes may be very, very technical, and it's not being submitted to the public to vote on, to whether or not to amend the Constitution. So comparing the word surcharge in a statute to the use of a word surcharge in a constitutional question that's amending the Constitution, I think we're looking at two different standards.
I would respectfully disagree, Your Honor, because when you submit a constitutional amendment to the voters, in my point of view, it is even more important to give as much information to the voters as possible so that they know what they are voting on. It's even more important for the constitutional amendment, the ballot question, and whatever supporting materials the chief election officer wishes to submit, to define that that surcharge is on real property tax.
I think that was my point, counsel.
Oh, thank you. I misunderstood.
The point is, counsel,
Sorry.
when something is submitted, in fact, if you go back and look at historically on our cases, the question has to not only be meaningful and clear, it's supposed to be informative, so you have an informed electorate and an informed voter so that they can make and understand what the implication of their vote is.
Thank you, Your Honor.
That's not what we do with enactment of statutes.
I absolutely agree with you.
Well, in this case, what about the reference to surcharge on investment real property? What is it about the phrase investment real property that the counties believe is too ambiguous? Because that's frankly the language that's in the actual provision. So what additional information do you feel should have been given in the question?
Well, the word investment is not defined. And I think almost everyone in this room who owns a house, I dare say, would hope, and when you buy a personal residence for your home, I dare say that everyone hopes that that piece of property is going to escalate in value so that you can build the equity and your financial stability for the future. By saying investment real property, the question, it appears to us that it's misleading and unclear because every single piece of property in the state of Hawaii is capable of being taxed as investment real property if you hope that the property will appreciate in value. Now, I know that...
Is part of the issue, I mean, is part of what you're actually arguing is that there's no election materials that are provided that would have explained this? I mean, we used to have a system where the LRB or the Lieutenant Governor's office through the election officer, they would supply election materials to the voter. And apparently, according to the record, this is all they get unless they ask some official if they could see the constitutional amendment, but there's no educational materials.
That's correct, Your Honor. It used to be that the Legislative Reference Bureau prepared voter information pamphlets. The law was changed to make it permissive for the chief election officer to prepare those types of information materials. In this case, to our knowledge, we've been told that the state does not intend to do that. So all you have here is the ballot question, and that is the whole problem. The ballot question, the 24 words, are not sufficiently clear to tell the voter what they are voting for. I'm sorry.
Don't they basically track the amendment itself? I mean, investment real property is the actual language of the amendment. So are you suggesting the amendment that the legislature or that, the public could not enact that type of language in the Constitution? It has to be more specific?
I would submit that it has to be specific enough so that the voters know what they are voting for.
Well, could you...
Can I?
I'm sorry, Justice McKenna.
I'd like to go back to what Justice Pollack was talking about. Article, is it 17? Section 3 says that the conditions and requirements for ratification of proposed amendments to the Constitution by the legislature shall be the same as provided in Section 2 of this article for ratification at a general election. So when you go to Section 2, it has a section entitled Ratification. And it talks a lot about the convention, a lot of this provision really relates more to convention amendments amendments through a constitutional convention. But in terms of the ratification provisions, where Section 3 says Section 2 applies, which provisions apply to Section 3? You seem to be, the county seem to be conceding that the program of voter education is not applicable to an amendment proposed by the legislature.
Actually, the procedures under Section 2 and Section 3 are a little bit different, and I believe that the procedures under Section 2, which pertain to constitutional amendments proposed by the CONCON, are different because of the more robust public hearings that are available during the CONCON to the public.
Then why should there be
among delegates?
But then why? I understand the Section 3 requires the publication, but in Watland versus Lingle, didn't this court apply a convention provision to a legislative constitutional amendment? In other words, paragraph 2 of Section 2 starts with, at least 30 days prior to the submission of any proposed revision or amendments, the convention shall make available for public inspection a full text of the proposed amendments. Every public library, office of the clerk of each county, shall be provided such text and shall make them available for public inspection. So it talks about the convention, but we applied the requirement to place them into the library as the requirement that was violated, and that was with respect to a legislatively proposed amendment.
So when I read Watland in connection with Blair versus Cayetano, in Blair versus Cayetano, it was also a challenge to a legislatively proposed constitutional amendment. There, the language was in the manner required for legislation, and the legislature tried to amend the procedures under Section 3 that applied to that constitutional amendment. The Blair court struck down that procedure, saying basically that the first step when the legislature proposes a constitutional amendment is for them to propose it, and then the second step is for the electorate to adopt it. But where the state attempts a different procedure that's obviously at odds with the express language of the Constitution, it should be stricken. Here, the procedure suggested by the state, which is to allow the state legislature later to define an unclear and misleading provision, in fact several of them, in the proposed constitutional amendment, is obviously at odds with the language of HRS 11-118.5. And in my point of view, the as provided by law language in the constitutional amendment, based upon which the state is arguing the legislature has the power to propose a constitutional amendment.
In terms of the as provided by law, don't we have a lot of constitutional provisions that say as provided by law with laws to follow?
That's correct, and if I had more time, I would get into a discussion about how that phrase really grammatically should be used to modify the preceding phrase as established by the legislature. They do not have the current power to impose a real property tax. What the state is using that phrase to say, as provided by law, like the situation in Cayetano, can be used by the legislature to define these ambiguous phrases through legislative enactment. But I am suggesting that HRS 11-118.5 prohibits unclear and misleading constitutional amendments to be proposed by the legislature, only to give them the power later to modify that unclear and misleading amendment through later legislative enactment.
So for example, in federal law, there was a voting rights constitutional amendment, and then implementing legislation. We have very broad provisions like the Equal Protection Clause. Are you suggesting that this statute somehow bans or prohibits a very broad constitutional protection from being enacted?
No, I do not.
I thought that's what I was hearing you say. So
no, what I am saying is that this statutory provision under 11-118.5 is a self-imposed standard that the legislature is saying that when we propose constitutional amendments, they should be clear and not misleading
Well, they can't.
to the voters.
The legislature imposed a limit on itself that it cannot adopt a broadly worded constitutional amendment. So assume we didn't have an equal protection clause. Is your view the statute would prohibit the legislature from proposing the adoption of an equal protection clause in Hawaii because that's too vague, it's too open-ended?
I would not
Why
make
not?
that proposition.
That's what I thought I just heard you argue that.
Well, the ballot is not just the question itself. The ballot is not just the constitutional language itself. The ballot would comprise the voter information pamphlet, had there been one. It would comprise all the potentially the legislative history that, might have been provided by the state. That would have given more meaning, more context for the express language that that is embodied in the 24 words. We don't have that here because there was only one hearing at the legislature for this particular 24-word constitutional amendment by the House Education Committee. It was not even heard by either finance committees, this particular language. And I would submit that because the ballot as a whole, which in this case only comprises the ballot question itself and perhaps the constitutional amendment, which I'm sorry, a lot of attorneys wouldn't understand either. The average voter needs to understand all of it.
Could I return to your point about the need for additional education on investment real property? Now, I understand from your position that you're suggesting investment real property can really mean just real property. Is that correct?
It could mean all real property.
Then are you rendering superfluous the concept of investment?
I don't believe so, Your Honor.
Well, if you recognize investment as having a definition, wouldn't that modify the term real property? Investment is meant to modify real property, and if it's confusing, I'm trying to get clear how you mean it's confusing, that investment doesn't have a meaning. I'm sure you're not saying that. You're saying it has too many meanings? Is that the idea?
I'm saying that it's not clear.
And as I understand
it's
it, you're
misleading
suggesting that investment means a property that's real property, a residence occupied by a resident, not for purposes necessarily of resale, but nonetheless it goes up in value, so that would somehow qualify it for the term investment property because it goes up in value? Is that the idea?
It could. I know that previous drafts of the bill that ultimately led to
Have you ever seen a definition like that where it becomes an investment property simply because it increases in value? Doesn't it require more in the sense that there's an intent to sell it?
I would suppose that there would be an intent to sell in order to gain from the appreciation of the real property.
So if there was enabling legislation to implement this provision, and the enabling legislation said that real property can be taxed for purposes of surcharge for education, wouldn't you concede that that would be subject to challenge because instead of a surcharge being imposed on investment real property, the surcharge is being imposed on just real property?
I would, if I could, Your Honor, answer with regard to previous drafts of the bill that ultimately became this constitutional amendment. Previous drafts of the bill limited its application to residential investment real property that was worth over $1 million. This language does not have those limitations, yet I have heard people say that this is limited to investment real property owned by folks who don't live in Hawaii, and that's worth over $1 million. They have interpreted the investment to have that type of application. All that I'm saying is that the language is sufficiently unclear and misleading so that the voters will not know actually what they are voting for when they vote for this amendment.
In fact, hasn't this court stated in Sierra versus Letitia Query Realty, 80 Hawaii 54, 1995 case, that real estate in Hawaii, particularly in Hawaii, is both scarce and expensive. As a result, the purchase of real estate or a residence likely is the largest investment a person in Hawaii may make in a lifetime.
That's
So
absolutely
we have
true.
characterized our homes as investment real property.
That's correct.
Ms. Leon, I think we've been asking you a lot of questions that have taken you over the time we'd allotted. I will allow you both to have, I'm sure Mr. Bilberry is wondering about his rebuttal time. I will give you both time for rebuttal, but unless you have anything at this point, perhaps we should move to Mr. Suzuki.
Thank you, Your Honor.
Very well. And again, Mr. Suzuki, if you're in the same spot, I'll give you some additional time as well. So.
May it please the Court, I'm Russell Suzuki, representing the respondents in this matter. You know, the petitioners come here today seeking an extraordinary writ.
Yeah, you're going to have to speak.
Sorry.
If you could, yes, thank you so much.
To get a second attempt to have the court review the constitutionality of Senate Bill 2922. The Circuit Court has already took jurisdiction over this matter.
Are you suggesting this court doesn't have jurisdiction?
Yes, I would. I would say that if, as an extraordinary petition, that because they have an adequate appellate process that they're utilizing, that under Briner versus Takano, that there is no extraordinary circumstances here to allow this court to review the matter when there is a pending appellate case pending in the Intermediate Court of Appeals.
Hasn't this court stated that it's preferable, actually, hasn't this court indicated it's actually preferable to have these challenges decided before the actual election? Haven't we suggested that?
I think there's no. I think that there is no emergency in this situation, because if the people have voted and the ballot question is defeated, there is no need to have any further judicial intervention in this matter.
Okay, so under that view, then why would a court ever view something prior to the election? You could just wait, gamble, wait to see if the public votes it down, but then if the public, even if an action is brought to the court, and even if it's plainly invalid, you're suggesting that a court should wait, allow the public to do it, maybe in this case even allow the legislature to enact a statute, and then a year and a half, 2 years later with an appeal, we invalidate it? That is in the public interest?
It's in the public interest because you're interfering in the legislative process. You have to give deference to the legislative process, and legislative enactments under Schwab are presumptively constitutional. The person that challenges it
Excuse me. Your response to me then is that it's always wrong for a court to intercede because you should allow the legislature, even though the legislature has passed a statute, the legislature passed a statute saying that the language and meaning of a constitutional amendment shall be clear and it shall be neither misleading nor deceptive. Even though the legislature has enacted such a statute, you're saying always never intercede, always let it go out to the public. And even though this court has interceded in the past, I'm not sure I understand the argument.
I'm saying that if there is a violation of the Constitution, then this court is the proper place that the person can go to get relief. If it's a statutory violation, then no, the difference needs to be given to the legislature in enacting legislation, because otherwise...
The legislature isn't enacting legislation here. The public is amending the Constitution.
Correct.
Mr. Suzuki, maybe I could follow up on that point about the way that we're supposed to understand the legislative action in this case with respect to the word surcharge. To the extent that you can you explain why surcharge is a preferred term as opposed to tax, which clearly would be something that I think the counties suggest would be more clear to the voters?
Yeah, I think the legislature chose the word surcharge to make a distinction between a tax on a tax or an assessment on a tax. And the title of the bill is a bill for an act relating to a surcharge as opposed to tax. So the remedy that the petitioners are asking for is that if the ballot question had used the word tax, that would have been okay with them. That would not have been okay because the title of the bill did not conform and did not use the word tax. It used the word surcharge.
Why not use the term surcharge on a tax?
Because I think in this case, the legislature was looking at a more defined definition. It's on investment real property. And so that's the distinction there. It's not a tax on it.
What is investment real property?
Investment real property is to be defined by the legislature because the constitutional provision says as provided by law. In the committee reports and
we're being somewhat put in the position of reaching for the idea of a clear definition, right? That's what the issue is here.
Couldn't as defined by law imply the law is already out there? I mean, couldn't a voter reasonably assume that this is all set somewhere as opposed to be determined down the line?
I think that's a possibility, but I think in this context, the constitutional amendment was not intended to be self-executing.
But if we amend the Constitution, no matter what the intent of the current legislature may be or might have been, this will be on the books unless it's deleted. This means that 10 years down the line, people's homes can be taxed, correct?
It's a possibility. It's the wisdom of the legislature to determine how, as provided by law, is to be implemented.
You would concede that the legislature could impose this surcharge on residential real property in which the that's owner occupied?
I would say that that's a possibility, but it's probably not going to happen because there is the review process by the legislature, as well as the governor will probably not permit.
For political reasons, but not as a matter of law.
Not as a matter of law, correct. That's
Suzuki, you just said a surcharge is a tax on a tax.
it's an additional charge.
So it isn't, you're not taxing the tax. You're saying it's I'm confused what you mean
I'm
by
sorry,
surcharge.
I misspoke. Yes, it's a surcharge is an additional assessment.
So it's not a tax on a tax, it's just an additional tax.
Right.
Let me ask you this. Suppose I bought a house, suppose I had the money to buy a house for my daughter, for her to live in, and that's why I'm buying this house. Is that included as investment property?
I think it's to be defined by the legislature.
How is a person supposed to vote on this? If I'm not buying this house in order, I think Ms. Leong mentioned, in order to have property increase as an investment, but I'm actually buying it for somebody to live in and not rent out, how do I know as a voter that that's not going to be taxed?
Then I think you should probably vote no.
Mr. Suzuki, Mr. Suzuki, I'd like to make sure I understand what this surcharge is. I want to read you something that you responded to the trial court, the circuit court, when you were asked, and this is what you said. The fact is, this tax, which I would call, it's actually Article 7 tax, is derived or calculated based on the property tax, doesn't make this a property tax. It is an independent tax that is calculated based on the property tax. And if you look at it that way, it's clear that the legislator used the word surcharge to make sure that nobody confuses the fact that this is not a property tax. This is a surcharge that is calculated based on the property tax. So if you look at it, there's a clear rational basis why the legislature chose to use a different word. So there's no confusion. This is not a property tax. Is that still your position?
I believe what I was trying to suggest is that the taxing power belongs to the state, and how it exercises that power. This provision.
Is it a property tax? You told the court over and over, here's your conclusion to the argument to the court. So that there's no confusion, the surcharge is not a property tax. It's a state tax upon that is calculated upon real property tax. So I'm asking you, is it you said it's not a property tax. Is it a property tax?
It's a surcharge, an assessment, a charge that's different from a tax, but it's calculated based on the real property tax.
So it's not a tax on real property.
It's a surcharge, right?
Mr. Suzuki?
Let me
Yes.
just follow. I'm sorry. One more question, because what you said here, that it's not a tax on real property, that it's calculated based on the property tax, is not what the constitutional provision says. Let me read to you what it says. It says, provided that the legislature may establish, as provided by law, a surcharge on investment real property, not a surcharge calculated based on the tax on real property. So my question to you is, how is this clear? If you're arguing that it's not a real property tax to the circuit court, but the constitutional provision says it is, as amended.
I understand your concern on that issue. I think that what I was trying to suggest was that the state has independent authority to impose a tax. This provision could have been enacted by the legislature as a tax. It chose
Without an amendment? Does the state have the authority to tax real property without this amendment?
No, if the legislature could have imposed a surcharge calculated based on the real property tax, that would have been possible.
Just to be clear, you're saying the legislature could have achieved everything that this amendment would achieve directly under the powers it currently has?
If they were to have worded the bill properly as a tax.
So, Mr. Suzuki, your interpretation of what you represented in circuit court was that the surcharge would be calculated based on real property tax. But that's not included in the proposed amendment to the Constitution. How is the reader, the average voter, supposed to know that it's calculated on a real property tax instead of on a value of an investment property?
I think what I was suggesting was that, as provided by law, that the legislature would have based the tax or the surcharge based on that type of formula or an analysis. If you looked at the initial drafts that went to the legislature, they were looking at investment property with a threshold of $1 million or some kind of threshold, and it's that kind of surcharge that was going to be based on that. Unfortunately, that's not what's before the voters now, because that's not the version that was passed out of the legislature.
But you're talking about value of the real property. What you said before was it was based on the real property tax. So isn't that different, and how is the average voter supposed to know that?
The average voter knows based on being educated by the advertisements, the committees for and against the ballot issues, reading the bill itself, as well as basically understanding or researching for themselves what the.
Isn't the point of the statute that the question itself is supposed to fairly lay all that out?
Yes, and I believe that it does. If the ballot question basically, if you read the ballot question as a whole, that it does make sense. It doesn't, if you parse it out to certain words within the question, then you may have a problem. But
I do have a follow-up question based on the language. Shall the legislature be authorized to establish, as provided by law, a surcharge on investment real property to be used to support public education? So is there anything as argued by the counties, is there anything that requires that any surcharge be in excess to what is currently funded?
It's to be determined by the legislature as provided by.
So in other words, it appears that the public may believe that the constitutional amendment would require that funding be increased. Would that be a reasonable assumption?
It's a reasonable assumption because.
Is there anything under the constitutional amendments proposed that would require an increase in funding? In other words, if this goes through and is ratified and there is a surcharge on investment real property as defined by the legislature, would the legislature then be required to add that amount to whatever general fund funding they were otherwise going to fund. In other words, couldn't these amounts actually be used to substitute for general fund funding, and the legislature is actually not required to increase public education funding, correct?
The appropriation powers are with the legislature, so that is correct. But the intent here is to fund public education under Article 10. You know, it's the state's responsibility, unlike other states.
I thought I heard you say it would be reasonable for a voter to assume that it would be additional funds. I thought I heard you say that a few moments ago.
Yes, it would be.
And if that's reasonable for them to assume, then how is the question clear or not deceptive or misleading? If that's a reasonable assumption that by voting for this, you're going to guarantee more money for public education, then how is this, and in fact that's not true, how is it not misleading?
It is true that the amendment would allow the legislature to use as a revenue source to fund public education the assessment based on the investment rule.
Nothing would prohibit the legislature under this amendment to totally fund public education based on a surcharge on investment real property, as many counties in the continental United States fund public education through county real property taxes. So there's nothing that would prohibit the legislature from imposing significant surcharges on investment real property, including people's homes, to completely fund public education. Isn't that correct?
I think you need to, it's just a possibility.
Well,
whether the legislature would do that or not.
Follow up on Justice McKennan's question. I'm sorry to interrupt you. So a voter that votes for this amendment with the understanding that now public education is going to be paid for through a surcharge on investment real property would be correct in its, the voter would be correct in its understanding of the proposed amendment. Is that right?
I think the voter could be correct. I think the general thing is that the legislature funds our public education system through revenues such as general excise taxes.
But if it's correct,
this would be a revenue stream that could also be tapped to supplement.
Sure. Well, I mean, if it is correct for a voter to assume that the purpose of this is to move funding of education to a source that is the surcharge on investment real property tax, then would you say that that's the information that's being provided by the legislature to the public? That that's what it is? It's to create an alternative funding source?
I think it's a supplemental funding source.
Supplemental.
Mr.
Which is different.
Because whether this revenue stream could totally support our public education system is probably the issue. If it's not, then it's the general fund that generally supports our school system. This would be an additional revenue stream to supplement it.
Mr. Suzuki, I'd like to go back and ask you about the question, because you were talking about how the question would be clear to the average voter. And the question again is, shall the legislature be authorized to establish, as provided by law, a surcharge on investment real property to be used to support public education? Does the question inform the average voter that the exclusive authority of the counties to tax real property is being amended? It's being altered. And what really, I mean, how would the average voter know that what you're talking about here is that the Constitution is being amended from one thing to something else? Is there any indication in the question? And let me ask you the follow-up. Is there any indication that the counties are already taxing investment real property? So does the voter know that it's being amended so that not only the counties, the state will be able to do it? Will the average voter know that this is a double tax potentially? I mean, is any of that in this constitutional question?
I think the average reader reading that provision would understand that this is something that's going to be an additional charge.
So the average voter, the average 18-year-old knows that the counties have the exclusive authority to tax investment property, and this constitutional provision is amending the Constitution to give this additional authority so both entities can tax the same investment. The average voter would know that based on the question.
No, not that the counties have exclusive authority over the property tax, but that...
Well, do you think when you amend a constitutional provision, you should tell the average voter that you're amending something from one thing to something else? Wouldn't that be... I mean, we want voters to make an informed judgment, don't we?
Sure we do.
Mr. Suzuki, I would like you to respond to Ms. Leong's argument regarding the as provided by law, that in other places in the statute where they use the phrase, the law has already been established, and it hasn't, in this particular case, it's an anomaly because it's a law to be established.
I don't believe that that's the situation. Board of Education versus YHA, as provided by law, was meant to be as the legislature prescribes, but the legislature has the authority to change the law, to amend the law to something else, and that it doesn't bind the understanding that it's the laws that are already in place. It's as the legislature determines.
Mr. Suzuki, may I ask you about the same question that I asked Ms. Leong about Article 17, Sections 3 and 2, and what portions of the ratification provisions of Article 17, Section 2 actually apply to legislatively proposed constitutional amendments?
Yes, my understanding was that it did not apply, the voter education provision did not apply to amendments made by the legislature. I understand you had a question, or you had the understanding that Watland changed that position and did establish that.
Well, no, actually, the provision does say the convention shall, as provided by law, be responsible for a program of voter education. And basically now what I'm understanding is that the legislature has actually rescinded the laws requiring any voter education program.
Made it discretionary with the chief election officer.
But even though the Constitution says the convention shall, as provided by law, be responsible for a program of voter education concerning constitutional amendments.
Right. So I think...
And my question is really based on Watland, because Watland applied provisions that relate to convention-proposed constitutional amendments regarding the public library, it being in a public library, to a legislatively proposed constitutional amendment. And that's why I'm trying to figure out which portions of Article 17, Section 2 also apply.
Well,
what's the state's position on that?
Because the legislature had enacted the discretionary authority to the chief election officer, and those provisions are presumptively constitutional, I would say that there is a distinction between amendments proposed by the Constitutional Convention and those that are proposed by the legislature. It's two different processes, and the legislative process has the benefit of having the committee hearings and the whole legislative process to flesh out those details and make those decisions as to what the proposal is going to be.
Mr. Suzuki, I'd like to ask you one more question about this as provided by law. I'd like to read the question to you two different ways. The first time, I'm going to delete a few words and then I'll put them back in. Right now it says, the way it was proposed on the ballot, shall the legislature be authorized to establish a surcharge on investment real property to be used to support public education? Shall the be authorized to establish? That's without the as provided. Should the legislature be authorized to establish a surcharge? Mm-hmm. With it, it says, shall the legislature be authorized to establish, as provided by law, a surcharge on investment real property to be used to support public education? When you read it with those words, as compared without those words, it would appear that it's already established.
I don't believe that that was the intent of the legislature. This is a new surcharge, so the program has not even been implemented, and therefore it's for the legislature to determine.
It's in the past tense, though. Isn't it used in the past tense as has been provided by law, as provided by law? Do you think it should?
No, I don't. Well, many constitutional provisions use that provision, and it's not with that you have existing laws established. It's as the legislature shall determine. I think that's the way that I would read it.
I'm sorry, which constitutional amendments actually were proposed that included this language in which the law had yet to be established?
I don't have any right off the top of my head, but it's when the legislature, when the Constitution provides the broad brush provisions for protection under the Constitution.
I understand
but it's
that.
not self-implementing, and you need to have legislation to implement the constitutional provision.
I understand that the counties are arguing then that these other constitutional amendments, there were actually already laws in place, and that's why I'm asking you what constitutional amendment was added to our Constitution in which the laws were not in place before the Constitution was amended to make it a constitutional right.
I believe Judge Crabtree in his circuit court decision referenced the concept that constitutional provisions are broad-brushed ideas, and they're implemented subsequently by legislation.
So basically, you cannot point
I
us
cannot
to
point
one
to
provision
directly right
All
now, but I think the concept is that generally constitutional provisions are not detailed
But that's
documents.
one thing when the constitutional provision is already part of the Constitution and it says, as provided by law, what the legislature would do. You're looking at a fixed document, and then there's a provision that says, as provided by law. Yes, that means what this is completely different. We're asking a question, shall the legislature be authorized to establish, as provided by law, a surcharge? It sounds like, or it could be read that way.
Well, let me ask you, Mr. Suzuki, is it necessary? Would this provision be defective if the words as provided by law were not included?
I think the word as provided by law suggests that the provision is not self-executing and it's going to require the legislature to.
Okay. I understand your interpretation, but let me ask you what your position would be if the legislature decided to just not include the language as provided by law. So it would read, provided that the legislature may establish the surcharge on investment real property, and then subsequently the legislature passes the implementing legislation for it. Do you think that language is necessary?
I believe the standard as provided by law language is understood to mean that the legislature has the authority to implement the constitutional provision.
Okay, but I'm not sure I'm
enacting.
making my question clear. Let's assume it's not there. Would your position be that this amendment would be
Self-executing?
self-executing, or on the other hand, would be sufficiently unclear that it would be defective? What would your position be?
I think the latter, that it would be sufficiently unclear, because if the provision is presumed to be or is suggested to be self-implementing, then you need to have the legislature to determine what those features would be.
What's your response to the argument that the prior versions had more definition and more specificity about investment property, and that was taken out in the ultimate language? Is that problematic at all from the state's point of view or not? And if not, why not?
It would have been better to have it clearly defined in the committee reports and in the bill itself. Unfortunately, the legislature decided to take some of that out. But I think what it still means is that, the whole purpose is to further educational funding for our public school system. And we have to trust the legislature to be careful in determining how and what kinds of assessments are going to be made to support the school system.
I want to make it clear that my questions do not in any way suggest that this legislature, the current legislature, would not go forward with what they said they were going to go forward with. But the issue really to me is whether or not the voters would understand that 25 years from now, a totally different legislature could decide to completely fund public education based on real property taxes. Do you think the voters understand that?
I think the voters trust the legislators that they elect that they would not do that, but there is that possibility that the legislature would have that power because as provided by law gives them that power.
Mr. Suzuki, my recollection, and it may not be accurate, about previous proposed constitutional amendments, the questions usually start out with should the Constitution be amended to? Why isn't that clear in this question to the voters?
I think it's clear, maybe not clear enough, but it is a bill for an act proposing a constitutional an amendment to amend Articles 8, 7, and 10.
And is that in the ballot?
It's on the title of the bill.
Is it on the ballot?
It would be, well, no, but it's available at the election booths.
Anything further, Mr. Suzuki, that you wish to bring to the court's attention?
I think I'd like to stress that there is an ongoing appeal and that this court should defer to that appeal because basically what the petitioners are doing is they were denied their relief in the circuit court and now they're coming before you to get a second bite at the apple. Thank you.
Very well. Thank you for your argument. Ms. Leong, your rebuttal.
Thank you, Your Honor. Very briefly, I would like to just address the one point that Justice McKenna had inquired of the Attorney General Suzuki, and that she had asked whether this court had indicated a strong preference for pre-election challenges when possible, and whether this court has stated that the better practice is to expedite legal action prior to the election. In fact, this court has said that in Bronster versus the state versus Bronster, 84 Hawaii at 185. And I would submit that this court has original jurisdiction and would ask for pre-election relief. Other than that, this rebuttal is on behalf of the City and County of Honolulu, the County of Maui, the County of Hawaii, and the County of Kauai. The County of Maui has elected to present its own rebuttal. Thank you very much.
Thank you, Ms. Leong. Mr. Bilberry, on behalf of the County of Maui.
I think I'm going to just have to drag you into the weeds.
Well, if you could bring the mic up closer.
Yes. Yeah, like I think I'm going to have to take you into the weeds here for just a minute, but I promise not to keep you there too long. I think this will address a point raised by Justice Wilson and then culminate and address a point raised by Justice Pollack. And it begins with the mention of GET and the state's, I guess you could say, comparison of what is a surcharge as proposed by the constitutional amendment and identified in the ballot as being the same thing as a surcharge that's been identified in HRS 46-16.8, 237-8.6, 238-2.6, and 248-2.6. And this is a surcharge that the counties are authorized to impose on gross income subject to a GET tax. Okay. That is not what is being identified in this ballot measure and in the Constitution, and there are three reasons that demonstrate that. They're critical distinctions. And it begins with that a GET tax is not an ad valorem tax. What is identified in this ballot measure for constitutional amendment is an ad valorem tax, not a GET tax. The basis for a surcharge, by way of example, the GET tax, it's based on income. It's an amount assessed against a fixed amount of income. The surcharge that is proposed on the ballot measure for constitutional, to amend the Constitution, is based on an assessed valuation of property. Big distinction. And here's the second distinction. The income that is the basis for a real surcharge is reported by the taxpayer. The surcharge which is proposed in the amendment is based on an assessed valuation which is determined by the tax authority. There's another distinction between this surcharge that's on the GET tax proceeds or income and what is being proposed in the ballot measure, which is an ad valorem tax.
Mr. Bilberry, while you're on that, if you could help me, I think the position Mr. Suzuki is taking is that this surcharge is obviously an additional assessment beyond the tax. Now, the surcharges that you've described also constitute an additional assessment. So why wouldn't that be the point here that the, in other words, the taxpayer that's voting would be able to understand that this is just an additional charge beyond the real property tax?
Yeah, what the taxpayer may not understand is that it's actually the basis of the additional charge. Again, there's a difference between a surcharge which is being levied against reported income by
But is
business.
it necessary for the taxpayer to understand the difference between the surcharge as it's applied to an excise tax or a use tax or a real investment, real property tax? Is that really necessary? Does the understanding have to go to that level for it to qualify on an amendment?
Yeah, I believe so,
constitutional
Your Honor.
amendment?
And the culmination of what I'm going to say will get directly to that point, and I think it goes to what Justice Pollock was saying. The third point on the difference between a surcharge, a real surcharge, as like provided by statute, and what is really a real property tax being called a surcharge, whether it's assessed against the taxed amount or the underlying assessed value, is that the surcharge is a tax on the person or the entity, and the entity is responsible for it. The surcharge that's being proposed in this amendment is a tax on property, and it attaches to the property by way of a lien. So this is not a surcharge that's being proposed by this amendment. It is a real property tax. If I can maybe dig into your question a little more. Let's say there's an assessment of a real property, be it an investment property or any property, under this proposed provision if it passes. The state's going to say, okay, we're going to levy a surcharge on the amount you've been billed by the Real Property Assessment Division. And you're noting the distinction between that billed amount on a amount of real property tax versus the underlying assessed value. So what happens then when the taxpayer appeals their assessed value? That's got to include the amount being assessed by the state on that taxable amount. So it's just not the same thing. And calling it a surcharge when it's really a real property tax subject to all the same indicia of an ad valorem tax, which is a real property tax, doesn't make it a surcharge.
But doesn't the phrase surcharge is commonly understood, and wouldn't that indicate to the voters that there or someone is going to be potentially liable for paying more, which is kind of the bottom line? Isn't that enough to convey? It's not hiding the fact that someone's going to have to pay more. Whoever it is that has investment real property is going to have to pay more, whether it's called a surcharge or a tax. At least it's the phrase surcharge indicates payment, right?
It's not hiding that fact. What it's hiding is that it's really a real property tax and that you're going to be paying more on your real property.
Well, I understand your proposition, but Mr. Suzuki points out that the reason it wasn't called a tax is because it's not a tax. It's actually something that's different than a direct tax.
Thank you, Your Honor. And we have provided to you 2 newspaper articles, one of which quotes the chair of the House Finance Committee, and she states repeatedly this is a real property tax. She's talking about assessed values. We have another quote from the Kauai representative who says that he voted for this reluctantly or with reservation because the language is unclear, not expressing what the legislature intends to do clearly. Now, just quickly, irregardless of which one of them is right, what this goes to show, how is a voter supposed to know this? if what the state's attorney is saying contradicts what the chair of the House Finance Committee is saying as to what this tax is. If those two state officials.
The bottom line is the fact that it's a charge and an additional charge is stated in the language. Is that enough to tell the voters? Is that enough to convey that somebody is going to have to pay more, whether you call it a tax or a surcharge? Somebody is going to be paying more, and that somebody is whoever owns investment real property.
Well, if your question is, does it advise the voter that somebody's going to have to be paying more, I would concede that it does advise them of that. But it doesn't advise them what it is that they're actually being asked to pay more.
But your point, I think, if I understood you correctly, is that instead of getting a bill from the state saying, hey, you owe $200 more, and it's just a regular bill, it's actually because that's what the amendment says. It's on the real property, so it's a lien. Your property could be taken away subsequently if you don't pay your taxes. In other words, whether you, either the real property tax or this surcharge,
right.
And that's, the voter would have no way of knowing.
That's a fair point, yeah. And I mentioned that, yeah, it's the basis of the tax is subject to lien, and that distinguishes what they're proposing as a surcharge via this amendment.
Mr. Bilberg, could you help me with the question I asked Ms. Leong? What sort of deference, let's say the county wants to amend the charter and has language that's before us that is being disputed as being confusing, or in this case, the state is before us. To what extent should this court give deference to the legislative determination of the language being, at least in the view of the legislature, clear, if at all? I mean, you heard the discussion having to do with the standard that's applied to whether statutes are unconstitutional, which has been interpreted as beyond a reasonable doubt, but I'm interested in your thoughts about what standard, if any, we should apply to this.
Yeah, first of all, I believe Ms. Leong characterized or made a pretty deft response to that particular point, but let me just note that the standard for reviewing a statute is, as I understand it, is a rational basis, not beyond a reasonable doubt.
Well, we're not
with
reviewing
respect to whether it's
statute.
I agree.
constitutional.
I agree. I
We're
100%
reviewing a
agree.
question,
No, I
not a
agree.
statute.
I agree, and that's the distinction I was about to make.
But
is
does
that
that
the
lead you
standard-
to the conclusion that actually there's no deference? We're just reviewing it, in a sense, de novo. We don't have to give any deference to the legislature?
The standard would be the average voter, not beyond a reasonable doubt, and not even a rational basis. If we're talking about constitutional language or statutory language, it's rational basis. Here we have to assume the position of the average voter, and I would say that would be more akin to a reasonable person standard.
I understand your answer to be we give no deference to the legislature on the question of whether it's clear or not.
No, I don't think that completely negates deference to the legislature. It just means that you look at it from another perspective, which is the perspective of an average voter.
How would you define the deference that we give?
Good. Well, let's look at it then from the perspective of the legislature. And I think you all have noted here they could have made this clearer. And we've heard argument from the state that they chose this word. They chose this word for a particular
That would
reason.
inhibit a lot of legislative work if everything that was unclear was also unconstitutional, right?
But I do think here we do have a very clear statement by the state's representative that the legislature chose this word to distinguish this tax from the real property tax. And yet we have a conflicting statement by the chair of the House Finance Committee, basically acknowledging that this is going to be a tax on assessed values.
Mr. Bilberry, has the County of Maui ever presented language that you think would have been acceptable?
On this ballot measure.
Right.
Well, I don't know that we were given the opportunity to.
What do you think it should have said?
Well, first of all, I think it needs to include language, as Justice Pollack has suggested, indicating that the Constitution is being amended to give the state some authority over a real property tax authority, which has been exclusively the counties for the past 40 years under Section 8, Article 3 of the Constitution. And it doesn't do that. And I think using the word surcharge is another way to get around having to do that. And particularly the notion that somehow this particular authority, which the state is now asserting occurs under Article 6, Section 1, which is, as I think this court knows, has nothing to do with enabling taxation authority, but is about, it states that the state cannot delegate any taxing authority to a non-governmental entity. So that's the first point, is that it needs to state that what this amendment is actually doing is redelegating tax authority, and it nowhere even comes close to that. And then it would need to say, potentially what it says is that the state is now going to impose I wouldn't call it a surcharge, they'd have to call it a real property tax, a tax on real property.
The question about redelegating authority from the state to the county, I mean, that's a very technical legal issue. You think at some point, is there a balance between pointing out every possible implication and putting a clear choice before the voters that folks can understand and get their hands around?
Yeah, that's a fair question, but I think this is such a fundamental issue, which is, again, taxation authority. Who has it? And the counties have had it under Article 8, Section 3 for the last 40 years,
Well,
exclusively.
the fact that
county
it's-
handles the appeals, the county does the assessments, the county has to, is dependent on the revenue.
The fundamental aspect certainly is apparent when it's a constitutional amendment. But when a constitution's amended, for example, to give the right to vote to a class of citizen that didn't have it before, that's pretty profound. But how much is it necessary to point out in the course of submitting that for a vote, how much is it necessary to make it clear that the right wasn't there before?
Well, you're talking about a right being bestowed on voters who
In other
have not
words, to
previously
some
had it, right?
extent, the assumption might be that a voter is sufficiently informed to understand that if there's a new right that's proposed or a new provision that's proposed, it's new. It's
Fair enough.
different than what was preceding it.
Yeah, fair enough, but we're not talking about a right here. We're talking about the authority of the state, which is different from the rights of a citizen.
Mr. Bilberry, Mr. Suzuki makes much of the fact of his assertion that legislative enactments are presumptively valid. But isn't that more in the context of the constitutionality of the statute? Are we looking at the constitutionality of the ballot question?
Yeah,
here?
no, I believe so, and I think that's been touched on. There's a difference between the standard that you're going to have to look at when you consider what an average voter is looking at when they're looking at a ballot versus the standard that may be brought before you later if this passes as to whether it's constitutional. And I would submit that if the authority being asserted for doing this is Article 6, Section 1, which is, again, it's a provision that provides that the tax authority is inalienable to non-governmental entities. If that's the authority that's being put forth to enable the state to do this particular amendment, then it is unconstitutional because that provision has nothing to do with enabling the state to issue any tax.
Mr. Bilber, anything to wrap up and conclude?
No, I just want to, I thank you for your time, Your Honors. I think we've covered it all, at least everything I thought needed to be covered.
Okay. Very well, then. Thank you to all of our lawyers here for your arguments today. The court will take this matter under advisement.
Oh, hey,